Order. Order. Robbie Moore to move the motion.
Thank you, Mr Pritchard. I beg to move that this House has considered E-petition 756036 relating to access to court and tribunal transcripts. And it's a pleasure to serve under your chairmanship, Mr Pritchard, and a privilege to be able to introduce this important debate on this petition on behalf of the Petitions Committee. I'd also like to put on record my thanks to the lead petitioner, Daniel Shen-Smith, for creating this petition, but also to Dr Natalie Benron, Adam Moren and Fiona Goddard, whose insights have proved invaluable on this issue to me in preparation for this debate. This petition seeks to make it a legal obligation for all courts and tribunals to make transcripts available free of charge. Currently, in both civil cases and criminal cases, an application for transcripts may be made for all or part of a hearing, with such an application generally requiring a payment of a fee. However, there are circumstances where parties can appeal where the cost of paying transcripts can be paid at public expense. For this to happen, the court must be satisfied of two things. The requesting party qualifies for free remission or is otherwise in such poor financial circumstance that the cost of obtaining a transcript would be an excessive burden, and it is necessary in the interests of justice for such a transcript to be obtained. This brings me on to the key question that this petition is seeking to address. Does Parliament think that access to records of court proceedings should be treated as a public good? The petition we are discussing today has over 200,000 signatures from members of the public, so it is clearly an issue that has struck a chord with many of our constituents. The problem, though, in my view, is that the current system is not fit for purpose. It undermines transparency and disproportionately affects those courts the aspiration of a court to protect its victims, bereaved families and those who are wrongly accused or who are seeking to challenge injustice. Let's concentrate on just how unfit for purpose the current system is. His Majesty's Courts and Tribunal Service commissions transcription services through a procurement framework, a pre-approved panel of private suppliers established via a competitive tender. The current framework was awarded in June 2023 and runs up until June 2027. Under this model, HMCTS pays suppliers for the transcripts it requires for court purposes. The transcription company is responsible for any anonymisation that may be required and applying any reporting restrictions that are in place. But when a member of the public requests a transcript, they must make a request to the court in which the hearing took place at and pay the transcription company directly at commercial rates. And if the hearing has already been transcribed for HMCTS or another member of the public, a lower copy rate will apply. If a member of the public wants a transcript of a court or tribunal proceedings, they must complete a lengthy form and pay the court the cost of the transcript. The cost will be determined by the length of the transcript, with transcription companies charging per block of 72 words. The more complex cases will have longer transcripts and therefore costs will be much more. There is only a handful of transcription companies as part of the tender process, and each one is attached to a particular court on a geographical basis, creating a monopoly with no competition. This only drives up prices, and there are accounts of people being quoted up to £50,000 for the release of these important documents. The government's website promises that those who apply for a free transcript will hear back within 20 days of submitting a request. If they are not eligible, they will then be invited to apply for all or part of the transcript and pay for it at a commercial rate. The fact that the judge assigned to the court case must give approval for the transcript to be released in the first place, and this process alone can add weeks, if not months, to that process. This is a significant problem for the groups that need to be that need to receive the most protection: victims, or in cases of death, their families. Because the court judge may rule otherwise and against a request that has been put in place, quite rightly, by victims or survivors that want to understand the true underlying decision that went into either the jury making a decision or as part of the court process at large. I will give way, yeah.
The honourable member for giving way, and in the spirit of cross-party consensus, commend both him for bringing forward this debate and the honourable member for Richmond Park for her campaigning work in this area. Does he agree with me that for victims it's vitally important that they have agency within the court process as a complainant, and that following a court or tribunal case that there is transparency for them regardless of what the verdict was in that case, so that they can understand the decision and seek to find closure after that process is concluded?
Mr Pritchard, I thank the honourable member for her intervention. I wholeheartedly agree with the points that she's making. In order for a witness or a victim or a survivor of a crime that has gone through a lengthy court proceeding process to then have to pay sometimes a huge cost to gain and ascertain the transcript to come back and be made available to them is deeply unfair. And actually, as a victim or a witness, you are only participating in part of that court case proceeding, and therefore not able to fully understand the complexities of the case, the contributions to the case that other witnesses may have made, and you are only able to ascertain the full understanding once the full transcript has been made available to you. And this brings me actually, Mr Pritchard, onto a very key point, which is under the unduly lenient licensing scheme. Victims and victims' families have just 28 days to appeal the sentences of their abusers. Having court transcripts is a vital part of this appeal process, and so the current system creates another huge barrier, in my view, to justice for victims and their families, because it may only be once they've looked at the transcripts that they may wish to put in a claim to the Attorney General for an unduly lenient sentence. Another significant reason for delays is the technology that is being used to record and produce these transcripts, as some courts rooms are still using tape recorders to produce transcripts. The need to create a justice system fit for the digital age is not a new one. A 2022 report produced by the House of Commons Justice Committee described the situation on court transcripts as unsatisfactory and recommended that HMCTS should explore whether greater use of technology, such as AI-powered transcription, could be piloted to see whether it could be used to reduce the cost of producing court transcripts. And on that point, I will give way.
I sort of almost want to have a bet on who mentioned AI first in this debate. For once, it probably is. It might be the solution. It's always said to be the solution, but which is that everything he's saying is absolutely right about the anachronistic and lack of transparent and costly and baroque system of transcripts. But there's a substantial cost here. We must move towards greater transparency. A good example of that is the Magistrates' Court and the fact that they currently do not have recording at all, but they will have after the Courts and Tribunals Act. But the solution has to be to do this stage by stage, is it not? And AI is going to be very important in that process.
And responding to the points that the honourable member has made, is that AI is a technology that exists, it is rolling out, and therefore, as part of even the recommendation that came from the House of Commons Justice Committee, is something that should absolutely be looked at by the government to make sure that court transcripts can be made available, ultimately, ideally, free of charge to the public, as I will come on to build the case that this is actually in the interests of public good from a transparency point of view. I now want to turn on to victims. I have been lucky enough to meet with many as part of the outreach in terms of preparing for this debate, because ultimately they sit at the heart of this. It is a sad situation, but in this country we have a judicial system that fundamentally disempowers victims instead of empowering them. Fiona Goddard is a woman that I have worked with for several years as a champion who has tirelessly campaigned for victims of grooming gangs. Fiona spent years being abused by a grooming gang in Bradford. When her case was finally brought to court, there were over 100 witness statements that she was not aware of. She therefore went on to describe that her contribution was literally only part of her own story, despite being the victim and witness within her own case. And this is a common theme that is experienced throughout the judicial system, where witnesses will only see and contribute to part and not be fully aware of the full extent of what all of those contributions have been to their individual case. Another case reported by the BBC was a woman from Berkshire who's endured a 7-week trial as a victim. The accused was cleared of rape, and the victim was told that securing transcripts would cost more than £30,000 for the whole trial. She said, "The entirety of my sexual violence trial hinged around me. There are 7 weeks of material that debated me, critically dealt with the details of my case, that included my words, my experience, and I cannot stress how that my levels of anxiety were increased. I waited 5 years for justice, and I leave the system mystified as to what happened." I would also like to refer to the case brought forward to this House previously by the Honourable Member for Richmond Park, and also commend her for her work in this space and all of the work that she has done in bringing many of these cases to the Houses of Commons. She spoke of her constituent previously who was drugged and then raped in her sleep by her former partner. She was then forced to wait 2 years for her case to be heard in court. Her attacker was finally convicted, but she can barely remember what was said in the courtroom, due quite rightly and understandably to trauma and emotional distress. She was left so traumatised by the trial that her therapist advised her to apply for transcripts of the proceedings to aid her healing. The application for a free copy of the transcripts was denied, and that she was then quoted a fee of £7,500 by a tender company for the court transcripts to be released. Victims... I will give way.
I thank the Honourable Gentleman for giving way, and I completely agree with the points that he's raising and the victims whose voices he's bringing to the fore here. Does he agree with me that the proposals by both the government and what has been passed in the other place as an amendment to the Victims Bill, which says that victims will have the right to the route to verdict from judges, is inadequate, because what it isn't is a transcript of the full case? And as he says, there is an importance for victims of crime in being able to work through with therapists and other support the full details of what happened in the period where they were not present in the courtroom in, as he rightly says, was their case. This is a way to re-empower victims to get closure after the event.
Mr Pritchard, I absolutely agree with the points that the Honourable Member has been making. What we are seeing in the other place through amendments that have been laid, and indeed what we are seeing from the aspirations of the current government in place, is not going anywhere near far enough in terms of increasing the transparency associated with ultimately having the full case and the full transcripts made available free of charge to any victim, survivor, witness, should they wish to get clarity, certainty around the court cases that they as individuals have been involved within.
I will give way. I'm grateful to him giving way, and he's making an excellent speech, and I fully support him in the case that he's making in terms of full transparency. But in a spirit of start by starting, he touched, for example, there on witness statements that will have been prepared before, but were still not available. Does he agree with me? There'll be certain aspects, if the principle is accepted around greater transparency by the Minister, there'll be certain aspects that could immediately be made much more available, whilst some of the other technical discussions are taken in parallel.
I absolutely agree with my right honourable friend, and the reason for that is because if you are a victim that has gone through a very, very challenging court case, even having immediate access to some of those witness statements and indeed contributions that have been made throughout the court proceedings that can be made without any difficulty by the ruling of a judge, then that will enable that victim to properly potentially seek closure on a result, on a sentence that has been awarded. But probably more importantly, if they wish to challenge the sentence, and we are currently faced through the unduly lenient scheme, 28-day period, gives them the ability to look at the transcripts, albeit what could be released in the short term, to provide the opportunity of potential challenge should they wish to do so. I will give way. Yeah.
Thank you. Clearly what we're talking about here is access to accurate court transcripts. I've been contacted by a couple of constituents who work as registered public service interpreters, and they've told me that they feel that the current system is very patchy and the quality of interpretation services isn't good enough. Indeed, someone can still act in the system without professional or vocational training as an interpreter. So would he agree with me that we must raise standards and ensure that there is a strong supply of level 6 qualified interpreters to support getting access to the transcripts we're talking about?
Mr Pritchard, I absolutely agree with the points that the Honourable Member is making, and these were some of the key points that were actually picked up in the report that was produced by the Select Committee for Justice, because they were not only advocating that better use of technology, but that there was a skill challenge amongst the various courts. And this feeds back to the narrative of the issue, in that when the tender was given back in June in 2023, they were based geographically, and once that tender is locked in, it's very difficult to alter it, even despite challenge and us raising it even in the House of Commons, and a petition coming down the line of over 200,000 people that have signed it. So I absolutely would like to, through me, take those points directly to the Minister, if that's okay. And I will give way, and then I'm going to make a little bit of process.
Can I just say, the Honourable Gentleman can give way, but the Honourable Member for Stratford knows, because he's been here a very long time, it's usually a courtesy in a convention in the House to be at the start of somebody's speech before they try to intervene. I think he came in some minutes after the beginning of the speech, so it's entirely up to the Honourable Gentleman, but that's the usual courtesy.
Very kind, but I will give way.
Can I thank the Honourable Member for bringing this forward? He's absolutely right to underline the issues. He's given a number of examples of where the process has fallen down because it hasn't been able to get the evidence to the victim. And the victims are the ones that I always focus on. And I know the Honourable Gentleman focuses on them as well. Is he aware of any cases or any examples where, because of not being able to get the evidence, and because the victim hasn't been able to ascertain all the information that was necessary, that the cases have actually fallen and that justice has not seen to be delivered?
The Honourable Member makes an excellent point, and in the outreach in terms of engagement I have done, those points weren't put to me, but based on the narrative of the level of concern around transparency and reassurance, then I suspect there could be examples of that are sitting out there, which is why over 200,000 people, I suspect, have signed this petition and feel so strongly that this is brought to the direct attention of the Minister, so that we can get better clarity and reassurance to many victims and survivors that have been through some horrendous court cases. But it brings me on to the point here that victims should and must be at the heart of the justice system, and yet time and time again they are made to feel completely disregarded, like an inconvenience, has been put to me by some of the victims that I spoke to. From those that I've spoken to, the level of feeling amongst victims is that trust needs to be rebuilt, and this is partly done through increasing transparency. It is timely to be having this debate as the Courts and Tribunals Bill, which represents the most significant reform to the criminal procedure in decades, makes its way through Parliament. With the abolition of jury trials for crimes likely to carry a sentence of less than 3 years, the Institute for Government has warned that judge-only trials risk damage to public confidence in a criminal justice system. The Bar Council Chair has cautioned directly that the reforms compromise public trust and confidence. In addition to this, local media is facing unprecedented levels of pressure. Gone are the days when each paper had a local court reporter to sit in on court proceedings. Despite the government's recently announced local media action plan, investment in local news while maintaining cost barriers to court transcripts is directly contradictory. Without affordable access to clear records of what is said in a court, local journalists cannot hold the justice system to account or ensure accurate information is shared with the public. So what can be done to increase transparency and trust with the justice system? Increased access to court and tribunal transcripts will absolutely be part of it, hence the nature of this debate. and I will acknowledge that some progress is being made towards greater ability of court transcripts. The previous Conservative government launched a pilot scheme enabling victims of serious sexual assault to request a free copy of the sentencing remarks, and that pilot was extended by the previous government last year. More recently, following pressure from the Conservative opposition, which tabled amendments to the Sentencing Act and Victims and Courts Bill, the government agreed to expanding free access to Crown Court sentencing remarks to all victims, but disappointingly confirmed that they had no plans to do so in magistrates' courts. There are several legitimate options for increasing transparency by access to court and tribunal transcripts. To start with, HMCTS could absorb the cost by paying suppliers for public request transcripts itself, rather than passing costs on to individuals. There could also be the creation of a central transcript repository, which would require transcripts already produced to be deposited in a centrally held scenario, such as the National Archive. The current tender process is locked in, Mr Pritchard, until 2027, but I believe that it is essential that public access requirement is built into the next framework tender from the outset. The government could also dedicate parliamentary time to proceeding and producing legislation that would be in place that would place a statutory duty on courts to provide transcripts, with funding flowing down into procurement requirements. I would also encourage the government to relaunch the Senior Data Governance Panel, which, having spoken to others as part of preparing for this debate, was set up by the previous Conservative government to provide independent expert advice of the use of justice data across courts and tribunals, but I understand that this has not been taken forward, much to the annoyance of many of those involved in the process. I conclude my opening remarks by reminding members in this place that this petition has had over 200,000 signatures from across the country. It is clearly an issue that demands time and good debate, which I'm sure we will have. Whatever the views of the public and members may have on this petition, it is clear that we have a justice system which is stuck in the past, is becoming increasingly less transparent, and makes victims that it exists to serve feel least important to all. And finally, when I come back to the overarching question put forward to this petition, does Parliament think that court and tribunal transcripts should be treated as a public good? When thinking of the cases I've outlined earlier, in particular of a quote from Fiona Goddard, who described the current system as just another way in which the victim is treated like the least important person in the judicial system, I think the answer is most definitely yes. It is in the interests of the public to make sure that these transcripts are free to access for all.
The question is that this House has considered E-petition 756036 relating to access to court and tribunal transcripts. Daniel Francis.
Thank you, Mr Pritchard. It's a pleasure to serve under your chairship, and I'd like to thank the member for Keelan Ilkley for those opening remarks. I want to briefly touch on my constituent Terry Louch. He was in contact with my predecessor prior to my election in 2024 and me since then. He's been trying to access the court records relating to his nephew, Mr J Sewell, who was murdered in December 2018. He applied to the Old Bailey for the transcripts and was told that the fee for these would be £22,000, £500 per day. He says that at the trial he was left with a number of questions, and that at times it was difficult to hear and understand a lot of what was being communicated. And he still, to this day, after several years, would like the transcripts to better understand the case proceedings and ultimately the judge's decisions. The perpetrator was found guilty with a minimum term of 21 years, but as I say, Mr Louch does still want to understand the full proceedings in the case. Now, I've twice raised Mr Louch's case with HMCTS. Initially, as has been said, they said that external transcription companies set their own fees and that isn't the responsibility of the MOJ, and that bereaved families can access a free copy of the sentencing remarks. But as I've said, for Mr Louch, it isn't just the sentencing remarks he wants the details of what was a very lengthy case. And latterly, with further correspondence, he was advised that he could apply for a limited section of the transcripts to lower the costs. But his position, Mr. Louch's position, is he's unable to pick out any certain parts of a given day, and that he would therefore have to pay for the full day to be described to access any aspects. And there are several days, of course, that he still wishes to have the transcripts of. And he says it would also be difficult to pinpoint which days, which specific days he would like. So that's the position after much to and froing from, as I say, both my predecessor in Bexley from Grayford and myself. It remains the case that Mr. Louch has not been able to access the transcripts due to the prohibitive costs involved in the case. And he continues to try and pursue that matter and pursue the aims of this petition. You know, I do welcome this debate, and I would ask the government to look again at some of those aspects, particularly those issues that Mr. Louch has brought forward, because I think for him to fully understand what actually happened, and again, what was a very traumatic case, the murder of his nephew, I think the cost of £22,000 is extremely prohibitive.
Thank you very much, Mr. Pritchard. It's a pleasure to serve under your chairmanship, and thank you also to the member Keithley and Ilkley for opening this debate so well, and particularly thank you for acknowledging my own campaign in this area. I also wanted to acknowledge the contributions of the member for Warrington North, who I see is no longer in her place, but I know that this is an issue for which she obviously has particular experience, as she talked about so bravely in the chamber the other day. And also a reminder to all of us that there are victims at the heart of this, and it is their rights that we are seeking to protect and uphold when we are calling for free transcripts. 3 years ago, my constituent, Juliana Tillitzi, contacted my office to request a meeting. She was quoted £7,500 for a copy of her court transcript. Juliana was a victim of rape. The perpetrator was convicted for the offence. Now, Juliana did not attend the trial due to the emotional toll that it would have taken on her, as is so common with victims who are still battling with the harm left from their traumatising experience. And as someone who's had no direct personal experience of ever attending a trial or having been involved in any kind of trial myself, I was really surprised to learn from Juliana that it is actually not routine for victims to attend the trial of the crimes of which they've been a victim. I guess my impression is all from television cop shows and court shows and so on, and I assumed that the victims were always there. But it is not routine, indeed is often in fact discouraged. Victims are not always encouraged to attend the trial. So while still dealing with the scars that the assault left behind, Juliana consulted with a psychiatrist who told her that perhaps reading over the transcript of the trial might help to provide some closure. But that's when Juliana was informed that a copy of the transcript would cost £7,500. Now, how can the UK claim to support victims of rape and sexual assault when such barriers which could aid their recovery still exist? Now, while I was frustrated at the length of time it took me to make the case to the last Conservative government, I'm pleased that members across the House are now more supportive of this campaign. And I'm also grateful that this government seems to have understood the importance of the issue, which has been backed by their commitment to making sentencing remarks free for all victims. And this is an issue which unifies the House. And as I have done for several years, I'd like to once again call for all transcripts of court proceedings to be free of charge. Every single member of this House will have the chance to make this call a reality by supporting Liberal Democrat peer Baroness Brinton's amendment to the Victims and Courts Bill when it returns to the Commons. So I would like to ask the Minister, will the government support this amendment? Over 200,000 people have signed this petition. Access to court transcripts is not a minor issue that will impact only a small minority of people. This change impacts all victims and their loved ones, and is a significant step towards enhancing the rights of victims while making our courts more transparent. I've been proud to lead this campaign in Parliament to amplify the voices of victims who've been met with this injustice. Victims of sexual assault and rape already face significant barriers when attempting to achieve justice. They're effectively a statistical anomaly when it comes to conviction rates. According to the charity Rape Crisis England and Wales, only 2.1% of reported rape results in a conviction. And that effectively means that 98% of people accused of rape will not face punishment. The current system is weighted against victims. Making court transcripts free and accessible is a step which can be taken to enhance the rights of victims, and I urge every member in this House to support Baroness Brinton's amendment. Thank you, Chair.
Some brush.
Thank you, Mr. Pritchard. It's a pleasure to serve under your chairmanship. And can I start by thanking the Honourable Gentleman for Keithley and Ilkley for opening this debate in his usual characteristic way, highly detailed, and bringing the voices of victims to the fore, which is so important in this. The petition before us speaks to a simple but fundamental principle, that access to justice should never be denied depending on a person's ability to pay. If our role in this place is anything, then surely it is to break down the barriers that our constituents face when trying to access that to which they are entitled. And this is clearly one of those barriers. And given that it involves access to justice, that most fundamental of rights, I cannot think of a more significant barrier that needs to be knocked down. I want to personally thank the 479 constituents in Hartlepool who signed this petition. Their voices reflect a real and growing concern that there should be a basic feature of open justice cannot be placed behind a paywall. At present, court and tribunal transcripts can run into the hundreds and even the thousands of pounds. For many of my constituents, that is simply unaffordable. The result is that people are denied access to a full record of proceedings that may directly affect their lives. That has serious implications for victims, for those seeking to appeal decisions, and for public confidence in a justice system that, frankly, is already under strain. I raised this issue of costs with ministers just like last week during justice questions, and I welcomed the response from the honourable and learned member for Finchley and Golders Green. And as an aside, I think I would like to say that my thoughts are with her and her constituents today. The commitment to make sentencing remarks available to victims free of charge is a positive and important step. It shows the government recognises the need to reduce these barriers and improve transparency. But there is a clear case to go further. The government's response to this petition suggests that expanding free access would place additional pressure on the system. And as we've already heard from other members today, in an age of AI and technology, I wonder whether that excuse stands up to basic credibility. This is not an optional extra. It goes to the heart of whether our justice system is truly accessible and accountable. It is encouraging that the other place has already taken steps, as has been mentioned, in this direction. Lord's Amendment 1 to the Victims and Courts Bill would create a statutory entitlement for victims of criminal offences to receive key transcripts free of charge, including the route to verdict and bail decisions, which is a clear expectation that they are provided promptly. That's a significant and welcome development, but still does not go far enough. But the principle behind that change should not stop there. If access to transcripts is essential for fairness and transparency, then it must apply more widely across our courts and tribunals. Open justice cannot be selective. It cannot apply in some cases but not others, or to some people but not others. The law belongs to us all. The records of our courts are part of the public record, and they should be accessible as such. Of course, there will be practical challenges, but those challenges should be addressed, not used as a reason to delay progress. With the right approach, including better use of technology, we can improve access while managing costs. Only where there are clear safety or national security concerns should access ever be restricted. Ultimately, this is about fairness and trust. It is about ensuring that no one is denied access to justice because of financial circumstances. I urge the government and the minister in his place to build on the progress already being made to support the direction set out in the Lord's Amendment and to move towards a system where access to court and tribunal transcripts is guaranteed, not priced out of reach. Thank you.
Steve Barclay.
Thank you, Mr. Pritchard. I've often found over the years, Mr. Pritchard, that when the frontbenches all agree on an issue, there are dangers for Parliament, not least because legislation is often insufficiently scrutinised. But conversely, when the backbenches of each of the parties agree, it is often, and certainly when I was a minister, a warning sign that the government of the day needs to move. And I think what has been uplifting about the debate that we've heard so far, with the evidence from the member for Warrington North, who spoke very powerfully, the the evidence from the member for Hartlepool on the government benches, but also my honourable friend, the member for Keighley and Ilkley, and also the member for Richmond Park, has been the consensus that this is actually a burning issue of concern to our constituents. And that has been a consensus from the contributions that we've had. And it's clearly a burning concern in terms of the volume of respondents to the petition. As my right honourable said, over 200,000. Again, signals that this is an issue that matters. And for the government, without diverting away from today's debate onto a related topic in terms of the restriction of access to jury trials, but given that direction of travel from the government, a direction that I regret, and indeed many on the government benches appear to regret, but given that decision, then the opportunity for the government then to move more quickly in terms of transparency on transcripts, I think is even more pertinent than it would otherwise be. The reason for intervening, Mr. Pritchard, in this debate is I'm very keen to hear from the Minister in terms of where he sees the sticking point as being. Because my sense from comments from the government today has been that broadly they're sympathetic to the direction of travel, and I think the Minister's sort of nodding his head to indicate that, and I've no reason to believe otherwise. And therefore it'd just be helpful, given that he and the government are sympathetic, to understand how the House supports them in moving more quickly. And in particular, whether the constraint is one of legislation, because as Mr. Pritchard, you know from past debates in this place, this House can move very quickly on legislation when it so desires, particularly if there is cross-party agreement, and indeed the member for Richmond Park indicated agreement in the House of Lords as well. So if the constraint is a legislative one, then there are ample opportunities for us to address that at pace. If it's a contractual one, then I suspect the sums are relatively modest, given the prize on offer. It'd be helpful just to understand what are the contractual costs if one were to try and terminate this agreement or to vary it. And indeed, where there is significant cross-party political pressure, it's surprising how suppliers, perhaps with a view to other contracts in the future, may be willing to make amendments to a contract should they wish. And thirdly, if the restrictions and the difficulties for ministers is technological, then what we saw with the period that we faced with COVID, which is again where there is a clear enough demand signal from government, it is surprising actually how quick technology improvements can be put in place when there is the will to do so. But I fear actually what is at fault here is not the minister. It is the slow pace at which Whitehall has a habit to operate. And that is why I think it's important through this debate that we actually support the minister in, I think, the direction of travel that he wants to go in, but understand where the blockages are. And so a few just quick questions from me. The first would be, given the government's support, as I understand it, for recording of proceedings in court, to what extent could audio clips, either in whole or in part of recordings, be made more quickly available? If there is some concern with the AI, for example, and its accuracy, are there other ways of solving that? In almost where can we start as opposed to waiting for the whole thing to be resolved? Secondly, as was touched on in my right honourable friend's remarks, witness statements. Huge numbers of documents are produced as part of the discovery process within court. Court bundles, huge documents are prepared in advance of the court hearings. It strikes me much more could be done to make those available, particularly to the victims of crime, than is the case. What assessment has been made of which of those parts of the court bundles could be done? And third, what exactly is the technology constraints? And again, when one looks at the progress in other areas of government and some of the commitments that have been made by the Prime Minister in terms of AI and wider number 10 summits recently, why can we not move more quickly than appears to be the slow pace that the Ministry of Justice are currently operating? And I think all of this really is particularly pertinent because of the point raised by my honourable friend, the member for Keighley and Ilkley, around the 28-day time limit for appeal. That is a hard deadline And yet, as he sets out, often decisions take a while to come. The cost is prohibitive, and people are not able to get that data, the information they seek, in a timely fashion ahead of that deadline. So my sense from the government is it wants to move in this direction. I hope the debate today has signalled the cross-party consensus to do so. When he has an opportunity to sum up, I would simply encourage the Minister to clarify exactly where the blockages are and remind him that if one reads Institute for Government reports, he will see that ministers have a habit of moving very frequently, and those who perhaps are seen as talented on the government benches often move very frequently indeed. And so he has an opportunity during his tenure in the Ministry of Justice to move quickly, to take advantage of the cross-party support, but also to do something, particularly at a time when his own government is restricting access to jury trials, that I think will be hugely helpful for victims and clearly is something that the public have signalled they very much want.
Thank you. We now move on to the front benches and Jess Brown-Fuller.
Thank you, Mr Pritchard. It's an honour to serve under your chairmanship, and I would like to thank all the honourable members who have spoken so thoughtfully today on this important topic, especially the member for Keighley and Ilkley for representing the Petitions Committee and certainly doing his homework, and for highlighting how mystified people often feel in a system where they go through a lengthy court process only to find out that their trial has been monetised or privatised and they have to spend thousands of pounds to have access to a case that was theirs. And I'd like to pay tribute to all of the signatories from across the country, 200,000 people, and I believe that the general public have got behind this petition so strongly because they are surprised that people are not just entitled to transcripts of their own case, because, Mr Pritchard, justice must be accessible and it must be visible. Trust in our justice system is built upon transparency, upon seeing the work and the reasoning behind decisions that affect so many lives. This is vital for defendants and crucial for victims and also for bereaved families like the Honourable Member for Bexley Heath and Crayford spoke passionately about. And today we have achieved consensus, as was said by the member for North East Cambridgeshire, that if we are going to break down barriers for our constituents, which surely is the most important role we can play in this place, as the member for Hartlepool mentioned, then this is one of those things that we can do that will make a genuine difference to people across the country that are engaging with the justice system. So the Liberal Democrats have long campaigned on this issue, particularly through the work of my honourable friend, the member for Richmond. Her campaigning for her constituent Juliana, a victim of rape who was told she would be charged £7,500 for her transcript, has been inspiring and I believe has truly shifted the dial, and I thank her for her advocacy in this area. And she highlighted a very important fact, which is that her constituent was still battling with the harms of that trauma and didn't hear the case that she was the victim of. And in order to be able to move on, she needed to have that document. And what is clear and has been reflected in much of the testimony today, as well as in national support for this petition, is that for many victims, court transcripts are a vital part of their recovery, be it personal recovery or via therapy. But for too long and for too many, these have been out of reach, reserved for those who can afford what can be incredibly large sums. Providing free court transcripts for victims is about giving them the support and protection they deserve. Many trials are lengthy, they take place years after the event, and they can be very re-traumatising experiences, even when victims do not attend in person. And everyone will handle situations like these differently, but given that victims are among the most vulnerable in our society, they should be afforded as much support as possible to overcome these challenges. And that is why consistent free access to transcripts is vital, and they must be available beyond the 28 days after a trial concludes to access the unduly lenient scheme. Such measures would markedly improve the experiences of both victims and survivors. That is why we welcomed the cross-party work in the sentencing bill to introduce the provision of free sentencing remarks for all victims. I would like to again thank my honourable friend, the member for Richmond, but also Baroness Brinton in the other place, and the various ministers in the MOJ, including the minister who's answering today, who worked to achieve this vital first step. However, we do believe that it is a stepping stone towards providing all transcripts free of charge. And the timing of this debate coming to the House couldn't be more pertinent, with the return this week of the Victims and Courts Bill from the Lords, which now includes the Liberal Democrat amendment tabled by my noble friend Baroness Brinton. This amendment will give victims access free of charge to transcripts relating to the route to verdict. This will extend current provisions encompassing bail decisions and judicial summaries, and it would avoid many of the extortionate costs we have heard about today and provide victims with clarity regarding their cases. And I want to thank the Conservatives in the other place for their support on this amendment, and I urge the government to get behind it on Wednesday. We will continue to fail victims without these provisions, and as with much of the government's rhetoric around improving technology and the use of AI in the court estate, there is little excuse not to put these provisions in place as quickly as possible. Thank you.
Hear, hear.
Dr. Kieran Mullen.
Thank you, Mr. Pritchard. It's a pleasure to serve under your chairmanship. Can I begin by thanking the member for Ilkley for opening the debate on behalf of the Petitions Committee. He's proving himself to be a consistent and doughty champion on behalf of victims and the issues that they raise with him. And I also want to acknowledge the member for Richmond in her long-standing campaigns in this regard. And I welcome this opportunity to discuss this issue as part of a wider debate we're having about transparency in the justice system. And sadly, I can predict to some extent, I think, what the Minister will say. 14 years will make an appearance, lots of rhetoric about how terrible the previous government was, absence of any idea of how they would have managed the challenges it faced any differently. I can also be pretty confident about what the Minister won't say. There won't be any real engagement with the challenges of COVID and what they presented to our justice system, even though they truly were unprecedented. But that's the standard the Justice Minister and Labour have set, not just in justice, but across the government on issues like inflation, energy bills, no acceptance of the challenges facing the previous government, no acceptance of the things outside of the government's control, and so it shouldn't be any surprise when they are held to exactly the same standard. But in reality, this issue is a good example of what more fair-minded commentators accept as a multi-decades-long failure to give the justice system and those affected by it the priority and resources that it deserves. I'm sure that if the Minister and I together were to design the justice system from scratch, we would agree that free access to transcripts was important and should just be the default. But we are where we are, and sadly I'm realistic about the success we're going to have on transcripts today, even with a petition signed by an impressive 200,000 people. This is the government, after all, that tried to delete the Courts Desk archive, one of the biggest steps forward in transparency in our justice system in recent years. I raised this directly in the House because I found the decision to delete a unique archive of corrected and correlated court listings and data deeply concerning. In the absence of retrospective access to court transcripts, the work of journalists is absolutely vital, and Courts Desk have become a valuable tool for journalists, campaigners and others to seek to identify patterns in offending and expose failings in our justice system. Rather than seeking to preserve that transparency while dealing constructively with any data protection concerns, the government moved towards deleting the archive altogether. Of course, their defence of this decision did not hold up to scrutiny. The Courts Minister came to the House and said there were serious data protection concerns. What the Courts Minister didn't tell the House was that the government's own internal processes had found this to be a low-risk incident, not even warranting referral to the ICO. So at a time when confidence in the justice system depends on greater openness, the Courts Minister was going to deliver the exact opposite, and this is part of the context for today's debate. It goes to the broader question of whether the government is approaching transparency in the justice system with sufficient urgency and seriousness. This petition speaks to a basic principle. Access to justice should not depend on the ability to pay, and open justice is not an optional extra, but should be considered only once the administrative convenience of the system has been satisfied. The petitioners are right to identify transcript fees as a paywall. For too many people, they're exactly that, a barrier to understanding what happened in court, a barrier to considering an appeal, a barrier to holding the system to account, and in some cases, a barrier to justice itself. And this matters not just for journalists or campaigners, but for victims, for bereaved families, and for ordinary members of the public trying to make sense of a justice system that's supposed to work for them. There is clearly public demand for greater transparency of the system, which is why the previous Conservative government started moving in this direction, including through the pilot of making sentencing remarks available free of charge to victims of rape and sexual offences. This was a start, and we should have moved faster and further while we were in government, I think, now. And across all of these issues, I just find it hard to compare any other walk of life where you'd expect a member of the public who is part of such an important process, both for them and their friends and family and to the wider justice system to be asked to remember key things that may or may not have been said at court, to be asked to be there every single day if they want to understand the full process when it wouldn't necessarily be appropriate. And what's disappointing to me in particular is not just the government's resistance on the full transcripts, but the much narrower and more readily available progress of making the sentencing remarks transcript available, which the government has refused to accept in relation to our proposals voted on in the Lords to have that done within 14 days and free of charge. The government will only accept doing that spring next year and not necessarily within 14 days. And as we've heard from others, because of the ULS scheme, people do need to have these transcripts quickly if they're going to be able to make good use of them. The public interest on sentencing remarks is particularly clear, and I look forward to the Labour MPs who spoke today backing the amendments that the Conservatives had inserted into the bill with cross-party support to make those the transcripts of the sentencing remarks available. And as the spokesperson for the Liberal Democrats has pointed out, similar amendments for victims specifically to have even more made available to them, including the route to verdict and bail decisions. Those two amendments with cross-party support that I hope Labour MPs and others will support when they come back to the House this week. Mr Speaker, Mr Pritchard, I think the member for North East Cambridgeshire showed his experience as a minister in terms of his questions and those that he put to the minister, which I think were very well articulated. And I'll add to those my own, really. It's all very well and good for the minister to talk in warm words about access to sentencing remarks and to court transcripts, but do we have an actual date for when the government is going to be delivering this? At what cases will it apply to start with? And what are the barriers that are preventing us from having this done much more quickly than the government is currently committed to? I want to pay tribute to all the people that signed the petition, and particularly those campaigners, for example, Fiona Goddard, that the member for Keighley and Ilkley mentioned, who focused on grooming gangs, and that's been a key driver, actually, of the demand for greater transparency in our justice system. And the government obviously resisted the inquiry on that in a similar vein of resisting transparency in our justice system. I look forward to the Minister giving some more concrete answers today about how we will make progress rather than just warm words.
Thank you, Mr Pritchard. It's a pleasure to serve under your chairmanship, and I've welcomed the debate this afternoon, or this evening even, which I think is a general consensus across party about the need to ensure more open justice and to do everything we can to ensure that, in particular criminal proceedings where victims are involved, those victims have access to the information that they need to recover from the crimes they've suffered. It is unfortunate, if I may, the tone struck by the Shadow Justice spokesperson. I, in fact, genuinely wasn't going to mention the 14 years of underinvestment in our courts, the fact that rape convictions went to record lows under the last Conservative government, that progress for victims' rights, and indeed many of the issues we've discussed today, were at a snail pace, if at all, under the last government. I wasn't going to make any of those comments, Mr Pritchard, but I feel obliged to do so, having been prompted by the honourable member. But there we go. I'm grateful, however, to the Honourable Member for Keighley, who has raised this issue both in the House of Commons and indeed elsewhere, and has done so again today, and it is an important issue. I want to acknowledge his contribution, all those who have engaged with the petition. It's clear, and the government knew that before this petition, but no doubt this has been compounded, that their representations underscore a real public interest in transparency across the justice system, and that's particularly important to the rights of victims, and those victims that have been specifically spoken about in this debate by my honourable friend, the member for Bexley Heath, the honourable member for Richmond Park, and again, I've said it on the floor of the House of Commons, but her work in this area has really led the way, and indeed many others as well, including the honourable member for Ilkley, who raised really powerful cases. I myself have met with victims. I have the privilege and also the humble duty to meet with victims on a regular basis in this role. And there is no doubt that our criminal justice system still too often fails victims. There is an issue about transparency to court transcripts and sentencing remarks, which I'll come on to, and I hope to deal with some of the specifics raised as to perhaps why we can't go as far as many would want us to at this moment. But I think there is also, from this debate and more generally, problems within our criminal justice system about how victims are simply dealt with within the system. We heard about information as to their trial and whether their attendance, and advice around their attendance, their advice as to the unduly lenient scheme is something that we are seized upon at the moment in relation to a piece of legislation going through Parliament at the moment. So there are lots of ways, culturally and systemically, that the criminal justice system fails victims, and indeed there is an acceptance there is more to do in this area too. But I want to set out the government's approach, what we have done, what we want to do, and by doing so I hope to deal with some of the detailed questions and challenges that have been posed in this debate. I want to start by reaffirming that open justice is a foundational tenet of our system. Open justice is the long-established principle that justice should not only be done, but be seen to be done, and is fundamental to the rule of law. Transparency also helps build confidence in the justice system, supporting scrutiny and enhancing public understanding of how the law is applied. This government is committed to ensuring the justice system is open and transparent. It is a priority we share with the judiciary. Both the Deputy Prime Minister and Lady Chief Justice have spoken at length about the importance of transparency and new technologies, as the chair of the Select Committee, who was here no longer in his place, said, no doubt offer opportunities to meet the rising public expectations of access to information. But the principle of open justice is not unfettered. We have a duty to ensure that it is delivered responsibly and in a way that safeguards the administration of justice. It is vital that we protect the rights of victims, witnesses and parties, and that sensitive information is handled with care. We must ensure that any measures to increase transparency do not undermine the effective operation of the justice system. That is why achieving the right balance is central to our approach to transcript provision. This petition calls for all court and tribunal transcripts to be made available for free in order to increase transparency, enable appeals and support victims. These are really important aims, and one that I hope every member of the House would support. But it is important to recognise some of the practical realities of producing transcripts, as well as the considerable progress already underway to improve access to such information across the justice system. And I will go on to expand upon that, but practical realities is not just infrastructure within courts, some of the contractual systems that the Honourable Member for Keighley and Ilkley have set out, but also some of the legal considerations and the context in which the judiciary and indeed all court transcripts are dealt with. Producing a transcript of court proceedings can be resource intensive. It is detailed, skilled work requiring rigorous quality assurance. Full hearing transcripts, especially those involving lengthy trials or hearings, multiple parties, interpreters, as was touched upon by the Honourable Member for Rushcliffe, who's just left, or sensitive evidence can run to hundreds or even thousands of pages. In fact, often from my experience, very likely thousands of pages. Ensuring accuracy is paramount because transcripts may be used in appeals, further proceedings or media reporting. Ensuring accuracy is paramount because they may be used in appeals or indeed be covered by the media. Errors can seriously undermine confidence in the justice system. Transcripts must also comply with relevant reporting restrictions and data protection requirements. In practice, this means detailed manual anonymisation is required to prevent both direct and indirect jigsaw identification of victims, witnesses, or other court users, a process current technology cannot safely automate, and which requires careful review to ensure no combination of details could reveal the identity of individuals protected by reporting restrictions. This is time-consuming, skilled task that requires precision to safeguard vulnerable people, as well as often legal advice too. The government has, however, made significant and meaningful progress on transcript provision, as well as wider transparency in the justice system in recent years. In the Crown Court, victims of rape and serious sexual offences and bereaved families in homicide, that is murder, manslaughter, and offences of causing death on the road, can request a free transcript of relevant sentencing remarks. This ensures that victims can revisit the judge's explanation in their own time and use it to inform any decisions that they may need to make, including whether to submit representations under the ULS scheme. Yes, of course.
For him giving way, and it's not surprising he's setting out some of the concerns that officials no doubt in the MOJ have raised with him around reporting restrictions, areas of accuracy in the text, which are all valid, but there's a danger the perfect becomes the enemy of the good. And could I raise two specific points? One, to what extent could the judge, as the trial proceeds, be earmarking packages of documents or audio recordings or other information as the trial proceeds that can be made more readily available, rather than the perfect being the enemy of the good? And second, the government has made a lot of passing a duty of candour. Is the duty of candour complied with if the cost of obtaining a transcript is so high the victim can simply not afford it, or it arrives after the 28 days that my right honourable friend spoke about?
The honourable member says that we cannot let perfection be the enemy of the good. But when it comes to court transcripts, of course, it is absolutely paramount, he no doubt understands it, that they are perfect. And I know he accepts and would understand that this is not simply, I'll come on to the other points as well, but this is not quite as straightforward as other public meetings being transcribed by the technology that we have today and turning it into a written document. I know he accepts that. There are no doubt more perhaps that can be done with regards to witness statements that are that appear in the trial as evidence in chief and are not challenged. Now, that may be an issue for the judiciary. I'm very happy to go away and look into it and speak with the courts minister, by the way. But it may be an issue for the judiciary. It's also maybe an issue with the CPS and the Victim Care Service as well. And as I said at the outset, one of my concerns when I deal with the criminal justice system and victims from all these different angles, whether it's court transcripts, which has been raised, whether it's the ULS scheme that I'm meeting victims all the time, it's that there is a problem culturally and systemically about how victims are not at the heart of the system in that process. And I fear that when it comes to that issue about whether there is more that can be done as a trial is developing or after the trial to ensure that the victim understands what is happening, gets the information they need, where it's possible and safe and legal, I have no doubt that more can be done. It may not be as easy as flicking a switch in 102 Petit France, but I'm sure there is more that can be done. I am somewhat wary of the honourable member's suggestion of recordings, and we need to be very careful about how we use recordings, either audio or visual of criminal proceedings. Again, he'll no doubt be aware of the sensitivity around that, but there is certainly perhaps more that can be done, and I can take away his suggestion, which is a more manual mechanism of making sure victims know and understand what has happened at the criminal trial. From spring of next year, the government will go further, and as has already been said in this debate, victims will then be entitled to be provided with free transcripts of Crown Court sentencing remarks relevant to their case. This is an important extension that will make a meaningful difference to victims' understanding of the outcomes of their case. As has been raised by the Honourable Member for Keighley, and indeed I think almost every contributor to today's debate, there is a clear interplay with the ULS scheme. And that scheme is being considered as part of legislation going through the House of Parliament at the moment. And the interplay between the transcript and provision of transcript and how we make sure the ULS scheme works for victims is something very much at the forefront of my mind and indeed the Minister for Victims' mind as well. Yes?
Just in regards to the point that the Minister's making, in his response to the petition, the government quite rightly said that by spring 27, the government is expanding free access to Crown Court sentencing, and that those transcripts will be made available to anyone that wishes to utilise the ULS scheme within the time frame that the ULS scheme provides. Given that that is 28 days at the moment, can the Minister provide some reassurance as to how actually the government is going to be ensuring that that level of information is provided within that time frame, or is it that they're looking at expanding, as I also wish the government to do so, the period of time for appeal beyond 28 days, which is far, far too short at the moment?
As I said already to the Honourable Member will appreciate the interplay between the ULS scheme and the provisions of transcripts of sentencing remarks is clearly right at the heart of our consideration as that bill passes through Parliament, and Parliament is seized of this issue of the ULS scheme. I completely understand the desire to expand the time limit. We've spoken to victims groups and victims who have suggested alternatives to that, and in fact are potentially not even in favour of that. We've got to get it right and watch the space on that, if I can say that at this stage. In the Magistrates' Courts, we're also making meaningful progress on the recording of hearings as part of wider reform of the criminal courts. Trial and sentencing proceedings in Magistrates' Courts will now be recorded. This will strengthen transparency and support the accurate production of transcripts when they are required. In civil proceedings, parties often do not need to pay for written judgments or orders in their own cases. These are provided as a matter of course, so that litigants can understand the basis of the court's decision and can consider any next steps, including appeal. Whilst there is generally a fee to pay for the transcript, the full transcript of a case, a party can apply to the court to obtain it at public expense. The court can order this where it is satisfied that it is justified by the financial circumstances of the party and it is in the interest of justice. In the family courts, most proceedings are heard in private. This is to protect the children's welfare and the privacy of families. Even so, progress is being made to increase transparency while remaining committed to the need to keep safe children and vulnerable individuals. In fact, family courts is often not at the forefront of our mind when we talk about this issue because they often sit in private. But actually, for many families, in particular in public family law proceedings, the transcript of any fact-finding or indeed any final hearing regarding the future of a child can be absolutely pivotal to the future care of that child and indeed the parents in any appeals or indeed routes to having children returned to their care. The government has worked closely with the judiciary to support an increase in the publication of anonymised judgments for family proceedings. This enables the public to better understand decision-making while ensuring that privacy is protected. Even where family proceedings are heard in private, journalists and legal bloggers can attend most types of hearing. And now, following procedural changes, family courts are encouraged to make orders setting out what information from these hearings can be disclosed publicly. This marks a substantial development in transparency in family proceedings, balancing clarity about what can be reported with the need to protect those involved. We're also working with Baroness Levitt with the Family Procedure Rule Committee to review current rules of court relating to sharing information from family cases to ensure the rules are justified and proportionate. Tribunals, which is also covered in the petition, play a vital role in resolving disputes affecting many areas of daily life. Across many chambers of the first tier and upper tribunal, parties can request fuller written reasons at no additional costs. Tribunals therefore already provide substantial written explanation without a fee. In the Immigration and Asylum Chamber, the upper tribunal already publishes its decisions, and the government is working with the judiciary and HMCTS to understand the arrangements required to deliver this in the first-tier tribunal. This involves careful consideration of operational capacity, safeguarding, and a significant volume of personal data involved. This work is ongoing and reflects our commitment to increasing transparency and delivering open justice. To go significantly further at this stage by extending free provision to every transcript across every jurisdiction would place substantial operational and financial pressures on the department at a time when we are rightly focused on implementing the extension of free sentencing remarks and a once-in-a-generation reform in our criminal courts. However, looking to the future, the government is embracing the possibilities that new technology brings. Advances in AI transcripts could allow for faster and more cost-effective production of court and tribunal transcripts whilst maintaining accuracy and safeguarding. Working with the judiciary, the government will continue to look at how we can go further and faster in this area. It is essential, however, that any such system meets stringent standards and ensures that reporting restrictions are adhered to and personal data is protected. In conclusion, I want to reiterate the government's firm commitment to open justice. We've already taken significant steps to strengthen transparency across the system, and we will continue to build on that progress. But in doing so, it is imperative that we can also protect individuals, recognise practical and financial constraints, and ensure the justice system can run smoothly and effectively. I again thank the Honourable Member for securing this debate and all members who have contributed, and I look forward to continuing to work together to ensure that our justice system remains open, fair and trusted by all who rely upon it.
Thank you, Minister. Before I put the question, just allow the move of the motion to wind up a couple of minutes if he so wishes.
Yeah, thank you, Mr. Pritchard. On behalf of the Petitions Committee and the over 200,000 signatures to the petition, can I thank all members for their engagement on what has been clear in our demonstration to the Minister, that on all sides of the House there is consensus that all of us wish to see transcripts be made free of charge to victims, to witnesses and to indeed to anyone who wishes to apply, to build better trust, better transparency in the process. All members obviously have a vote on this issue, potentially this week on Wednesday, so it'll be interesting to see how the government benches instruct a vote to take place. But just quickly in terms of response from the Minister, who was articulate in what he was delivering, but it feels that there is an issue of the system stalling. And dare I say, whilst I will give the Minister the benefit of the doubt in his aspirations to unblock this system, it'd be a key. What I would really like to understand from the Minister, he referenced in his response to the judiciary being responsible and the engagement that the government has to have with the judiciary. What I would like to understand is, who at the judiciary is the government having this level of correspondence and communication with, and perhaps he could write to the Petitions Committee with a level of understanding as who the individual is that potentially petitioners, members of in Parliament also need to be engaging with to try and unlock this situation for the good of all of those that signed this, and indeed all members across the House who have brought their concerns to the Minister today.
Question is that this House has considered E-petition 756036 relating to access to court and tribunal transcripts. As many of that opinion say aye. For contrary, no. I think the ayes have it. The ayes have it. Order, order. The sitting stands adjourned. Have a nice evening. Thank you.